Item 12 is moved from the regular calendar to the consent.
Just 12A or 12A and B?
Just 12A.
Move to approve.
Second.
Moved by McGuire, second by Lang. Any discussion? All those in favor?
Aye.
Opposed? Item number 7 is Division of Elderly and Adult Services, Choices for Independence Program.
Mr. Chairman, this is mine. I had just 2 notes to the committee. At the top of page 1, I made a comment regarding the fact that the rules had expired in February of 2020. And then at the end of the rules, the public hearing on this was held in June of last year, so we'd made a comment about having the in-person as well as the Teams option. But otherwise, I have no public comment, but, I have no comment, but we are expecting public testimony. And we've received written testimony, which I think you all should have copies of.
Okay, please be as precise as you can, as we have extensive amounts of testimony. Tell us who you are.
Allison Zeno, Administrator for the Department of Health and Human Services.
Turn your microphone on. Thank you.
There we go. And hi, I'm Wendy Altman. I'm the Bureau Chief at the Bureau of Elderly and Adult Services.
Representative McGuire.
Thank you, Mr. Chair. I would very much like to know what you've done in the last 2 years, since you can't enforce an expired rule.
The Bureau of Elderly and Adult Services has requested that providers and the Bureau operationally follow the expired rules during this time.
That doesn't answer the question. You can't enforce an expired rule. What did all the providers voluntarily agree to follow the rules?
Over the time that the rule has expired, we have had the majority of providers, if not all providers, follow the expired rule. And we've provided additional guidance during that time in terms of following the language that's in the expired rule.
Yeah. So, Allison, can you give us some explanation about what's happening that you guys can't formulate a rule in years?
So this rule, as you know, has. Sorry. Is this better? Okay. This rule has been in the process for quite some time. It has started as an interim rule back in 2019, I believe. And at that time, we have had various department staff enter into this process. It was once Kim's role, and then I had taken it over. The attorneys had switched places, and we've also just been trying to work with, with MCAC. There was a subcommittee, and then again, COVID had hit in the middle of this as well. But we have had meetings with the MCAC subcommittee via Zoom over this time. The department has extensively tried to work together through all the testimony and comments that we have received to make this rule out to be as best as it can. And it just happened that it has taken quite some time to do that.
I understand that they've been working on this for a while, but that's why we changed the law to say you cannot enforce an expired rule. It's, if I were one of the providers, I would just have done whatever I thought best and ignored you for the last 2 years. And there would have been nothing you could do to stop them.
Representative Hatch.
If I may ask, I sense that maybe you don't share or agree with the gravity of expired rules, because it can put the state in an untenable position, and it seems to happen time and again. And there are excusable circumstances and understandable circumstances, but we're talking about 2 years, and I just sense it's being treated a blum. It's not vitally important, and I can't stress strongly enough how concerning that is, because of the jeopardy that the state could be placed in because of this. Just my thoughts, and if I'm incorrect in my thoughts, just explain why, please.
No, I agree that it is not our intent to have expired rules, and we try to prevent that the best we can. And we've been working really hard to make sure our rules are not expired and do not get into situations like this. But as to the effect on the state, the attorneys would have to speak to that. I cannot.
Sure, follow up.
Okay, so is it because there's a lack of personnel, or there's a lack of resources to do these in a timely manner and have them put out as they are designed to be done? I'm just really concerned. And why I'm concerned is I've been on this board for many years, and this is just a systematic problem. It just seems to reoccur and reoccur and reoccur from the same agencies. And I just really, there's got to be a line somewhere, or a reason. And if we need to address the lack of personnel, the lack of resources, let us know, because that's what we're here to do. Thank you.
Thank you, Representative Hatch. For the record, my name is Melissa St. Cyr. I'm the Chief Legal Officer for the Department of Health and Human Services. Mr. Chair, if it's all right, I'd like to respond to Representative Hatch's question. Thank you so much. So we absolutely agree. I mean, expired rules are not something that we want to do as a department, and we certainly try very hard not to have that happen. There's lots of situations, and each rule we have to take, there's many reasons why somebody or a rule would not be put forward in a timely way, or a rule would expire. In this situation, obviously we had the COVID pandemic. There is federal law surrounding this rule, and that federal law changed dramatically during the COVID pandemic. There were lots of requirements and responsibilities, one of those being that we couldn't actually remove anyone from the program at the time. There were waivers, there were changes in things that occurred that made this rule very unique and different. In addition to that, there was a lot of stakeholder involvement and engagement and changes that needed to be made, a lot of work that the department did with those individuals, and lots of comment that we had received and had to take into account when we were working through the rule. Add the pandemic on top of that, and absolutely a lack of resources. We only have 2 rules coordinators for the entire department, and we have hundreds of rules in the department. We have we had a cut of about 300 staff this last budgetary session, and so there's a significant lack of resources on the department's perspective to be able to work through these things. And as you know, when the rules are 80 to 100 pages, that can have that can take a long time to edit, to adjust. So there are many reasons, but I do want to tell you that it is something that the department looks at. We are absolutely trying to get rules in a timely way, and apologize to the committee for having these expired rules, but it's certainly not something that we hope to do or strive to do in any way.
Sure. Problem?
The chair serves on finance in the Senate. I serve on finance in the House. And there are times when different departments indicated they did not have the resources to work through the rules in a timely manner. And we added legal staff. We added staff necessary to do that. And I don't recall a request for that to happen, and that goes to my concern. I mean, it might be a circular thing we're doing here, but if you need resources, let us know, and we'll do what we can to provide them. And I mean that, and I can say that with comfort, because as the chair will verify, we have done this more than once. Thank you, Mr. Chair, for your tolerance.
Thank you. Let us know what support you need from the legislature to get your job done.
We will. Thank you so much.
Go ahead. Do you, anything else? No. Okay. And we have testimony from Carolyn Virtue.
Good morning, Mr. Chairman, members of the committee. Thank you for this opportunity to appear before you on this rule. I chair New Hampshire's Medical Care Advisory Committee. As such, I have worked with the subcommittee on this rule since 2019. Michelle Winchester, health policy analyst, who many of you know, is the chair of that subcommittee. Very unfortunately, she was unable to be here with us this morning. The Medical Care Advisory Committee to support the comments and objections included in Michelle's letter, which you should have before you. I was asked the other day why the HEE 801 is so contentious. I've given it a lot of thought, and I believe it's because we backed into the rule. Formerly, there were laws passed by the state and the feds, and we created a rule to develop the program. In this instance, was a new idea for the program, and the rule is being used to try to back into that. And that's where a lot of the objection from the providers come to. Instead of following legislation and federal mandates, we're trying to back a rule into the program. The rule before you is governed by a plethora of federal citations, and they are referenced nowhere in the rule. The CFI program is largely federal funded, and we have lost sight of the applicable governance of that program. At the very least, I beg you to recommend the department reference the guidance contained in the applicable laws and rules. This is absolutely necessary to have a system which provides the department measures to be compliant in day-to-day operations. This is the only way we can get to a system with quality outcomes for the participants. Mr. Chairman, may I respond to Representative McGuire's question, please?
Sure.
So as the department stated, they asked the providers to play along in the rule-less system. I can only speak for myself as a provider in the system, and I made every effort to do so. My objections came in when the department enforced the HE 801 on the consumers of the program by not approving services. And when that happened, I will agree, sitting here before you, that I made a world-class fuss on behalf of those beneficiaries. But never as a provider did we revert my agency to ignoring the rule, and I don't believe other agencies did either. But to Representative McGuire's point, you cannot deny someone care if you don't have a valid rule, and they did.
Questions from the committee? Senator?
Thank you, Mr. Chair, and thank you, Carolyn, for your testimony. Do you have a sense of how many individuals, and you say consumers, but we're talking about people here, right? Individuals, these are our, mothers and fathers, our grandparents, trying to have the best life possible. How many people do you think were impacted by those denials?
So I would say in my organization, it was, first of all, I don't have those numbers before me, but I work daily in the system, and I would say over the course of the 3 years, probably 10 to 15 requests a month, depending on whatever was the hot topic at the time. And I will say that the department did not appropriately issue the denials, so it wasn't and the consumers were not given their right to appeal through the Administrative Appeals Unit. We were just notified through a comment in the system that it would not be covered. And I am happy to provide redacted proof of any of my statements made here today.
Question to the chair. So you said 10 to 15 a month. Is it the same person in some cases, month after month after month? Or are these all discrete individuals? Discrete
requests for services. So there may have been 2 or 3 requests for the same individual. Does that answer your question?
Yes, thank you.
Thank you.
Go ahead.
So, thank you, Mr. Chair. So, if I heard you correctly, these denials happened without adequate written notice?
Yes, they were refusals to approve the service request is how I'll refer to them. But this is one of the problems with not having a rule. There's no process for the notice of the denials to the client for the denial. And to your point, Senator, if there isn't a rule, we can call them something else. And in this case, by giving it another name other than denial, the department's decisions are not subject to the process set forth.
Follow up? So regardless of the rule, my understanding is that these are Medicaid services, so federal Medicaid law requires notice, correct?
I believe you are correct, but and I'll let the department speak for themselves, but I don't think that, well, they may or may not agree with you, but it didn't happen. I'll leave it at that. And that is one of the reasons, one of the many reasons, we ask you to include applicable federal law in the appendix of this rule.
Other questions? Thank you.
Thank you, Mr. Chairman. It was a pleasure to get up and run out in a balmy 2 degrees to see you all.
If you have a response, we'll hear it now.
Yes, thank you, Mr. Chairman. Again, for the record, Wendy Altman, Bureau of Elderly and Adult Services. I thank Carolyn for her testimony. I believe that much of what she has described, either that her agency experienced or perhaps some of her participants have experienced, reinforces the need for us to have an approved rule as part of this process. We do have state statute and our regulations and our federal program, which is the approved Choices for Independence waiver, to also follow when individuals go through the process of appealing a decision when they do get notice. I don't know of necessarily any specific individuals who were denied an authorization that was put into the system, and when it's denied did not get notice. I am not aware of any of those situations. With an expired rule, we often do have times where we have discussions with providers and participants who may be looking to get authorization for services either sooner or we're determining the need for that service before an authorization is put up. Perhaps that may be what Carolyn is speaking to, but I'm not aware of at any time where we haven't provided notice to somebody who's been denied a service authorization.
Representative McGuire.
On a separate issue, why don't you have the appropriate references to the federal rules and laws? Because if, as a federally funded program, I'm sure they influence how people act.
So we would like, if we could editorially, add, like Carolyn has requested, the federal citations to the appendix of the rule. We're happy to do that.
Thank you.
Thank you.
Other discussion, questions?
What are our options, Mr. Chairman?
Staff?
The committee can either approve the amended conditional approval response, or they could issue a preliminary objection.
I move we approve the amended conditional approval response with the request that federal citations be included editorially.
Motion and a second. Discussion. All those in favor?
Aye.
Any opposed? Okay, let's not have this type of discussion in the future.
No, sir.
Are there any rules now that you're pretending to enforce that aren't enforced anymore?
Not that I'm aware of,
Okay,
but we do have 3,000 rules in the department, some of which I've not seen yet.
okay.
Thank you.
Thank you.
Department of Agriculture.
Yes, sir, this is my rule. The proposal has one issue remaining, and that's on page 7 of the linked PDF. If you look there, there is one comment towards the bottom of the page. Basically, the reason for the comment is because here the rule is stating that a licensee's license will be automatically suspended if the licensee doesn't have sufficient proof of local zoning approval. And that's problematic because 541A 30 Roman numeral 3 only permits suspension in specific circumstances. And then also the underlining statute here, RSA 437-4, authorizes suspension only after notice and to the licensee and an opportunity for hearing. So that's the one remaining issue on this proposal.
Is the department represented here today? Take a motion for an objection. Motion by Hatch, second by Lang. All those in favor? Aye. Opposed? Department of Safety with interim rule.
So this was my rule. It's 2020-12 interim rule. It's on SAFC 9700, and there are several clarity issues. This is pertaining to the body worn and dashboard camera fund. So departments around the state would apply for funds to reimburse them for purchases on body worn cameras and dashboard cameras. And the clarity issues could be fixed in either a preliminary objection or in the regular rulemaking process. My concern is just, I can go through everyone if you like, it's just the number of clarity issues are concerning, and it's unclear what the department is asking for in terms of information on an application to receive funds.
Good morning.
Good morning.
My name's Marta Montagnani.
You have to
representing the department.
pull that microphone
Oh,
over.
I'm sorry. Representing the Department of Safety, and I have with me Director Steve Lavoy. These rules were very much modeled after the law enforcement substance abuse grant that we currently have. While we appreciate the comments that we did receive, we're hoping to get these rules approved and to incorporate those suggestions and comments in the permanent rulemaking, which we have already in the pipeline. I believe the public hearing is scheduled for February 4th.
So on February 4th, this is all going to be,
February 4th is the public hearing for the permanent rules.
okay. Have a motion on the interim rule.
Move to approve.
Motion by Lang, second by Burstein. All those in favor?
Aye.
Opposed? And we have a discussion on the emergency rule for the emergency enhanced technology ignition interlock device implementation rules. Tell us why you need this.
I'm sorry, I missed that completely. I'm sorry.
Tell us why you need this emergency rule.
So we need these because the enhanced interlock device became effective January 1st of 2022. We currently submitted the emergency rules that allow for the licensing of the service providers as well as the data that's required to be reported for the service providers. Currently, we do not. We do have current rules for the non-enhanced ignition interlock. Those will expire on January 31st, and we submitted the permanent rules, which rulemaking that are identical to the emergency rules. I'm sorry, you look like you're going to ask something. Oh, I'm sorry. So we've submitted those, and those are scheduled for a public hearing in February as well. But because the enhanced device became effective January 1st, we wanted to be able to provide a robust program for the providers, the users, and so on.
Okay, Mr. Todd, tell us who you are.
Oh, I'm sorry.
Okay.
Good morning. Thank you, Mr. Chairman. Thank you, members of the committee. My name is Michael Todd. I'm the Deputy Director for the Division of Motor Vehicles.
Do you have anything to add?
No, I believe Marta covered it well.
Okay, thank you. That's it.
Thank you.
OPLC.
Thank you.
Mr. Chairman, did you want any input from me regarding the emergency rule?
No.
Okay.
I already told them we don't like them. The emergency rules that are.
So this OPLC rule is OPLC 1000, and it is dealing with the, let me get this right, Professionals Health Program. And there's only one comment. It's referring to rule on page 2, 1001-08C, where a fee is required for initial applications. The problem with this, as you can see from my comment on page 4, is that we believe there's a lack of authority, as the statute does not mention initial applications. It only it only references renewing of licenses for the fees, and 541A 22(3)(c) requires specific authority when requiring a fee. And the other issue is just explanatory. The FIS says that there is no difference in cost when comparing the rules. However, the fee is increasing from $16 to $20, so that is a $4 difference.
Good morning, members of the committee. Lindsay Courtney, Executive Director, OPLC. With me is Doug. I'm going to mispronounce your name, Doug, so I'll let you.
Douglas Osterhout, General Counsel for OPLC.
Thank you. I disagree that there's a lack of statutory authority. I think when you look at RSA 310A :1-E, the office's authority to establish fees, both at annual and biannual license, is clear. That's set forth in 310A 1E, Roman numeral 1A. That said, I recognize that there is somewhat of it's somewhat ambiguous, right? Reasonable minds can disagree, and I think that we have that demonstrated here. So I draw the committee's attention to the jail car declaration of November 19th, 2020, in which this committee voted to approve unanimously a motion presented by Senator Jay Kahn as a result of the failure to pass SB 576 in the 2020 legislative session, that when reviewing proposed rules from agencies under the office, support that it is legislative intent pursuant to the enabling statutes RSA 310A :1-D as amended July 1st, 2018, and RSA 310-A :1-E as amended respectively June 30th, 2019, that the adoption of all fees pursuant to RSA 541A for the agencies is under the authority of the OPLC Executive Director unless specifically exempted by subsequent legislation. So I think this committee has already made clear that the legislative intent of all these statutes was that the office and the executive director has authority to set fees. We are required by statute to maintain a professional health program. This committee may be aware, but we've had issues. I think getting a contract approved, and that the executive council rejected the last 2 contracts we put forth and requested that we enter into a sole source contract with the higher bidder. So obviously we have a statutory requirement as well in order to assess costs that cover our operating expenses. We would not be able to meet that statutory mandate unless we assessed fees.
Questions from the committee?
Actually, my
Mr.
questions-
Chairman, did I hear her say the highest bidder?
That is correct. It happened twice.
Mr. Chairman, my question is actually for Representative McGuire. As ED&A Chair, I think she can speak to the fees conversation about the conflict between
Yes.
what our staffing is saying that they need
Yes.
statutory authority.
We did, in fact, pass a bill, I think it was last year, maybe the year before, that said they have the authority to assess fees. However, we did not specifically list every specific type of fee that the boards charge. We listed the major ones, but we left a few out, and that will need to be cleaned up. And in many cases, we didn't delete the authority in the specific board statutes that assess fees or specify a fee. Therefore, we're in a major cleanup process to delete the fee authority from the boards and put it back to OPLC, but the legislative intent is, in fact, to have them set the fees and cover all the expenses and not have to deal so much with the allocating the copier costs among the 50-odd boards. So yes, I would say she's correct.
Okay.
I'd move to approve.
If I may, Mr. Chair, just to follow up on Representative Smith's question, and it's kind of stuck here. Did I hear you say that you as an agency went through the process of bids, suggested to award to a certain vendor, and when you got to governors and council that they insisted on an alternate vendor that was more expensive? Can you expand on, I'm sorry if I may, Mr. Chair, can you expand on that? That's stuck here.
Yes. Yes, this happened twice. We put it out to bid, and each time that contract was not approved. The concern of two separate councils was that the vendor that we awarded the contract to was an out-of-state vendor.
Well, that adds some light to it. Thank you.
Yes.
Thank you.
I'll renew my motion to approve.
Motion by Lang, second by Burstein to approve. Any discussion? All those in favor?
Aye.
Any opposed? Microblading certification.
Yes, sir. This proposal would put into place some regular rules for the microblading certificate program. There's currently an interim rule in place. This proposal would put the regular rules in place. There's currently an interim rule that's in place. If you look on your agenda, this item and the upcoming interim rule kind of go hand in hand, and Christina will talk about that interim rule. As you may remember, House Bill 70 of 2021 established a microblading program, but it didn't set any fees. And while the executive director of the OPLC has fee authority, pursuant to RSA 310A1E, the rule references an application processing fee and states that it's going to be in PLC 1002, which doesn't currently exist and is actually in the interim rule that's next on your agenda. So that's really the only substantive issue with this proposal.
Okay, so we have an emergency rule that is in effect.
You have an interim rule that's in effect, yes, sir.
Okay.
Followed by an interim rule that's next on your agenda that would put into place PLC 1002 that actually has the processing fee for the applications.
Perhaps we could have revised the agenda so as to deal with that rule first and solve this issue.
Okay, so let's go to the interim rule.
So the interim rule on microblading certificate fees, there is no issue that I have. It's just a note to Jelcar on the FIS because there was a typo in the FIS, so there was some confusion there, and the FIS said that there was no. I'm sorry, I've lost my place. so they were saying that there was no fee before this, but the rule is being changed from 405 into 1002, and so the fee did exist before, and it is being increased from $110 for a 2-year license to $155 for a 2-year license. So there is an increase in the fee, and I just wanted to point out that the fee did exist before. It's just they're moving it into this other section of the rules, which they do have the authority to do, and they do have the authority to increase the fee. I just wanted to clarify what was happening there with that fee.
Move to approve.
Second.
Okay, we're suspending the vote on the previous motion. And we have a motion to approve. Any discussion? All those in favor? Aye. Any opposed? Now we'll take up Representative Lang's motion to approve. Any discussion there? All those in favor?
Aye.
Did we need to fix that reference? You pointed out that it was rule whatever, but it was in the following motion. Did we need to do any editorial? No? Okay.
No.
Thank you. Thank you, Chair.
Mr. Chairman,
Yes.
Mr. Lang's, Representative Lang's motion, was there a second for that?
Yes, Representative Burstein.
Okay.
Okay. All those in favor?
Aye.
Any opposed? And we have an emergency rule. And can you tell us why we need this emergency rule?
Absolutely. So Senate Bill 155 last year was adopted that would extend the emergency licenses that were issued under the governor's emergency order, under the executive order, from the end of the state of emergency to January 31st of 2022. I think the hope was that at that time, individuals would have converted to permanent licensure and that we would not be experiencing the healthcare workforce shortage that we are experiencing today, as well as obviously the COVID-19 remains ongoing. So this rule was promulgated. We promulgated this rule under the authority to issue temporary licenses based on the same criteria that we issued emergency licenses. It's RSA 310A, RSA 310A, I want to say I. We converted the licenses from emergency licenses that were slated to expire on January 31st to a temporary license that's valid for 120 days under the statute, which would give our 22,000 healthcare workers that presently have an emergency license additional time to seek permanent licensure, as well as the general court additional time to determine what, if anything, should be done with these emergency licenses.
Questions from the committee?
Does this apply to our military personnel? We're talking about the idea of a given military MOS having a civilian designation and allowing them to be able to use that military MOS over to a civilian designation to allow temporary services in our healthcare fields.
So the temporary licensing authority only applies if you have a license in another jurisdiction. There are some bills out there that that would allow us to utilize the military service designation, basically in order to issue licenses based on portability. OPLC would support that. This the current statutory authority doesn't allow us to do that, with the exception of last session we were able to pass a bill that would allow us to utilize service members' experience to transition to LNAs, but that's the only category that I'm aware of.
Mike.
Mr. Chairman, I don't question at all the state of the emergency here. It's very clear. The authority is arguable, but what I'm concerned about is I believe these rules directly conflict with the legislation that the legislature passed last year that said these licenses shall end January 31st, 2022. I understand the agency's between a rock and a hard place. I assume that when the legislature put that date in there, they perhaps thought that the emergency would be over by that date, and it obviously isn't. So I understand why the agency's doing what they do. I'm just concerned that they don't have, that it conflicts with legislation.
And your thoughts on that?
While I agree that the purpose of SB 155 was to have emergency licenses end, I don't think it conflicts with my existing statutory authority under RSA 310A. These are two separate licenses based on similar criteria, but it's under different authority. So I don't think there's a conflict because we're utilizing a different statutory provision.
Ms. Lindsay, do you, in 120 days, do you forecast coming back again with another request?
I don't have the statutory authority to do that. I think that we can only do this once. I know that there is pending legislation, I think it's Senate Bill 277, that would extend further the emergency licenses. My initial proposal had been to actually convert the emergency licenses so that people could be forced to go through the licensing renewal and revetting process. I don't think that that is going to move forward. Some of the boards had concerns about that. Our hope is that it'll give it the opportunity for the legislature to figure out what to do. And on May 31st, if there's not additional statutory authority to extend the licenses, these licenses will expire.
Any other questions? Thank you. Board of Architects.
Yes, sir. This proposal makes a lot of changes to the licensing rules for architects. There are many unclear comments and that still need to be addressed. There's also a comment regarding the inadequacy of the FIS. I had a discussion with Tina Kelly with OPLC yesterday, and the agency is prepared to take a preliminary objection and to work with our office to remedy those issues. They also, my understanding is they've also filed a request for an amended FIS with the LBA, and we'll be submitting that with the preliminary objection response as well.
Move to object.
Second.
Motion by McGuire, second by Lang. All those in favor? Aye. Any opposed?
Thank you very much. Another
emergency rule from the Board of Pharmacy.
Good morning. Lindsay Courtney, Executive Director, OPLC, here on behalf of the Board of Pharmacy. This emergency rule, so presently right now, in order for practitioners to dispense drugs at an ambulatory care setting, a pharmacist has to be present, and they can only dispense for a maximum of 72-hour supply. There are some new medications, treatments for COVID-19 that have recently come out that go above and beyond 72 hours. So this emergency rule was promulgated to modify it to make clear that practitioners are permitted to dispense the full course of treatment for those drugs.
Questions from the committee? Thank you. Board of Education.
Yes, sir. The board filed a conditional approval request, which you do have linked on your agenda. It was late filed, and they did receive a waiver to file that late. Like I said, it is attached to the agenda, and I'll be referring to comments made in that document. The board has resolved some of the issues, but there are still some that can't be resolved because there really needs to be a legislative fix. Those are summarized in the very large comment box on page 15 of the linked PDF. The first substantive comment of note is on page 9. And here we are highlighting the fact that the vendor will be receiving confidential student information, which the board has defined. And that's going to include medical information and student educational records. The department clarified that the vendor will get this information from parents during the application process. However, that's not spelled out in the rule, nor is it known whether or not parents can opt out of providing that information. It's also not known whether the vendor is aware of or knows what the procedures are that the LEAs use to protect that confidential information, or what oversight the board will take to ensure that protection procedures are followed. And we do note in the comment on the large comment box on page 14 some of the issues around delegation and oversight. If you look on the bottom of page 9, we're just highlighting for you that there is testimony from Attorney Zellin, and just to highlight for you that you may want to review that testimony in regards to the broad scope of RSA 194F2 Roman numeral 2.0 and the need perhaps for guardrails and oversight by the board. But as I just said, we do talk about that on page 15 as well. You go to the next page on page 10. There's a comment highlighting the fact that right there in the middle of the page that 194F is silent on whether or not these education service providers need to have criminal background checks in order to have direct contact with children. And the rule doesn't actually require that. Like I said, 194F is silent on it. And so it's not clear whether or not the provider should be getting criminal background checks. So the statute may need to be amended to affirmatively require that. The next comment is on page 11, on the bottom of the page. Just scrolling down there to it. So here, what we're saying is that the rule here, and just to be clear, C2, where it talks about a determination of disabling condition, is what the comment is trying to address, is that the rule is in conflict with both 194F2 and 19840A. And the reason being is that 194F2 says that the commissioner will distribute differentiated aid that would have been provided to the school for that, provided to the public school for that student. And 19840A states that differentiated aid is done, if you will, for or is determined for students who are considered special ed. And the only way a child is determined to be eligible for special ed is a determination by an IEP team, and not the second criteria here, which is actually in the rule, which says if they've been determined by a medical professional as having a disabling condition. And so this rule is creating a new category of eligibility for differentiated aid, which conflicts with the two statutes that I just mentioned. The next comment is on page 13.
Let's stop right here. And
Sure.
what we're going to suggest, we're going to move this to the continued meeting date and see if you can get this act together.
Would we submit a revised proposal?
You're going to keep working on this with the staff and get it.
Okay.
This is just too many things.
They would be able to submit an amended conditional approval
Right.
request.
What? Yes. Oh, this is Chris Bond, New Hampshire Department of Education. Just to clarify, when would the continued date be? Because the board has an interest in having the rules acted upon before the interim rules expire.
Right.
It would be, excuse me, my mic is not working. It would be There it goes. First week of February.
Okay, thank you.
Senator Whitley.
How about that?
This apparently was not a high bidder or low bidder issue, so, in every meeting room in both buildings.
Thank you, Mr. Chair, for suggesting that continuance. I think there's a lot of work that needs to be done. So I will note also we received comments from Attorney Gilles Bissonnette about his concerns that the rule needs to be amended to indicate that public funds should not be used for religious instruction. And he was very clear in laying out how, if the rule is not amended to address that, that could violate the New Hampshire Constitution. So I would suggest that the department also discuss that issue with Attorney Bissonnette, and then, of course, with Attorney Zelen. I would suggest everyone gets together and address the significant concerns that are with this rule. Thank you.
Thank you. Any other,
Amanda Phelps.
any other
Amanda Phelps.
business?
Yes, Mr. Chairman, we do have some comments regarding electronic filing. Christina is going to handle those.
So we just have a couple things we wanted to let the committee know about. One, on your agenda, there's linked a memo from Director Dave Alcunis. It is regarding our current, or no longer required submission by agencies of original signed documents. So previously, they would send them through email, and then they would send through interoffice mail the original documents. We're no longer requiring that. It required the director's approval because we are having to suspend certain things certain requirements in the manual. We are also actively updating our manual to comply with our current process of electronic filing. And the other thing we wanted to let you know is there was some discussion in 2020, I think August of 2020, about our files and how we were keeping them and whether we were going electronic. And what is happening now in our offices as of January 1st, 2020, everything before that date is a paper file that is being properly archived. Everything after that date is going to be an electronic file stored on our electronic servers with backups all over the country. And so that is what we are doing now. We are fully electronic and we are taking no more paper copies. So if you have any questions, just let me know.
Questions? Thank you.
Mr. Chairman, I believe we also need a vote on the previous item, the education rule to postpone.
Motion.
Second.
Motion by McGuire, second by Lang to postpone. All those in favor? Aye. Opposed? That it?
Yes, sir.
Meeting is adjourned.